The jury in the Karen Reed case was unable to reach a verdict, and the judge declared a mistrial, dismissed the jury, and set a date for a status conference. From the time that the jury was dismissed, before the status conference was even heard, the defense brought a motion to dismiss, arguing that the jury had in fact reached verdicts on counts 1 and 3 and was only unresolved or unable to reach a unanimous verdict on count 2. And for that reason, the judge should dismiss counts 1 and 3 and not allow the Commonwealth to retry Karen Reed on those counts. Count 1 being the most serious count against Karen Reed, which was the second-degree intentional homicide. Count 3 being the hit and run causing death. Count 2 is the confusing one that I broke down on a podcast that has a bunch of the lesser included crimes by statute. Those lesser included crimes are included by law. We went through the jury instructions and where there could potentially be confusion, and it seems in this case that there is. Jurors reached out to the defense and said, wait a second, we came to verdicts, but we didn't know that we were supposed to fill out the verdict forms if we didn't come to a verdict on count 2 or the lesser includeds in count 2, but we need you to know. So the defense made a motion to dismiss and then brought in supplemental responses. The prosecution made an opposition saying, no, we can do what we want. I mean, in my head, it was in Cartman's voice, but no, the verdict isn't a verdict unless it's taken in open court and put on a verdict slip. And that's not what happened here. So the Commonwealth said, we have the right to go and prosecute any of the charges against Karen Reed on a retrial. That retrial has now been set for January of 2025. What's coming up this week on Friday, August 9th, is a hearing on oral arguments regarding this motion to dismiss. The defense is arguing that this is double jeopardy. They don't have a lot of legal room to argue here because A, this doesn't happen often. Often juries are polled. These jurors were not polled. And the error can be remedied if you poll the jury. Is this your verdict? Is that your verdict? Does this reflect your verdict? So the defense made their motion and then subsequent supplementals indicating more jurors had reached out. A juror reached out to the media and said, yes, this is all accurate. Then the Commonwealth made their opposition. Then the Commonwealth filed a supplemental and the defense filed another supplemental yesterday. What the defense wants ultimately is for the court to dismiss counts 1 and 3. Legally, I don't know if the court can even do that. I truly don't. The law is not on the defense's side in this, but what most of you are going to say, but Emily, how is that right? Right. What is legal and what is moral are at odds here under the law as I see it. So if the court denies this motion, I think it will go up on appeal. What I think the defense ultimately wants is to be allowed to talk to the jurors about their verdict only, or bring the jurors in like they did in Murdaugh. Hey, juror number 1, did the jury reach a verdict on count 1? Yes. What was it? Did the jury reach a verdict on count 3? Yes. What was it? And that's it. So now we have this tension between what the law can do and what the jury seems to have wanted to do, but you need to ask every juror. You can't just go, well, 4 of them said that they reached verdicts, so the court's going to dismiss the counts. You kind of need to know if the jury was in fact unanimous. And the only way to do that is to ask the jurors, which should have been done before a mistrial was declared. But this jury no longer has any power over the case. The problem with that is that if you spend 10 weeks on a jury and you render a verdict, or you think you render a verdict, and then you think you need to ask the judge, you know, hey, we couldn't reach a verdict on this, what do we do? And the judge is like, I'm declaring a mistrial. How frustrated. I think the jury system deserves an answer on this question. And I think the jurors deserve an answer on this question. Imagine you're that juror, how wrong that would feel to you if you're like, you can't retry this woman for murder because we acquitted her of murder. So there is a tension in the law here. I don't think the judge can just dismiss the counts under all the law that we've seen. I think there is room to argue that the judge can inquire of the jury. And I think that's probably the defense's best argument, is to get the jury polled so that they can say, this was a unanimous jury. The error is in the way the jury instructions are written. The judge should have polled the jury. The defense didn't ask. The defense said they didn't have an opportunity to. The prosecution didn't ask. But I think the jury should be allowed to give their input here. And I think there's room under the law for that to happen. Then I think the only remedy is the Commonwealth dismissing counts 1 and 3, which they can do. I think the best outcome for the jurors and the defense is to allow the jurors to be heard via affidavit to the court directly, or having them come in and being asked. And then it's going to be on the Commonwealth to choose to dismiss the counts or not. And again, prosecutors are elected. So the people of the county have the ability to say to their elected officials, seriously, WTF with this. But you can't do that without all of the jurors. You can't do that on 4 jurors. You have to do that with all. But the law does not allow you to open the door into jury deliberations. I think there is a strong argument that asking the result is not asking about the nature of deliberations, though I can see the argument on the other side. Because they never rendered a result in court, asking what they did in the jury room is asking about deliberations. I think there's room to split hairs on that. And because I think there's room to split hairs on that, I think it's going to have to go to the appeals court. I don't think we're going to have a resolution on Friday. I think we're going to hear oral argument and the judge is going to take it under submission. This is not an easy, clear answer, I don't think. And if the judge does rule on Friday, it will be a denial. The judge choosing to do this or choosing to allow the jurors to be questioned is the legally more difficult result, right? Just denying it's a pretty easy result. Allowing the jurors to be polled is a more difficult result. So I think the judge taking it under submission allows the judge to contemplate what can be done here and truly what's the right result. But the result in the interest of justice, that is up to the prosecution to do. Do I think they should? Yes. Am I confident that they will? Nope. Commonwealth's post-trial notice of disclosure. The Commonwealth received emails from 3 individuals who identified themselves as jurors. These individuals indicated they wished to speak anonymously. On July 16th, the Commonwealth responded to the emails by stating the Commonwealth would, quote, welcome the opportunity to discuss the evidence or the Commonwealth's case. However, we are ethically prohibited from inquiring as to the substance of your jury deliberations. That would include your individual or the jury's collective thought process, the content of your deliberations, or the reasons for your decisions. It was further explained that the Commonwealth could not promise confidentiality and that the substance of any communications may necessitate disclosure to the defendant or the court. All 3 jurors declined to further communicate with the Commonwealth and provided no information about the jurors' purported votes. So going through the additional new documents today, we have looked at another supplemental from the defense indicating that one of the, who I'm calling the game of telephone jurors, whose acquaintance, friend, or somebody they communicated with came forward to David Yannetti. That juror has come forward directly to David Yannetti and confirmed their statements that the jury didn't believe Karen Reed knew she hit John O'Keefe with her car, that they were unanimous on not guilty on counts 1 and 3, and they were stuck on count 2 on the lesser included. No one thought she hit him on purpose or even knew that she had hit him, which means to me that the jury was contemplating that John O'Keefe was hit by a vehicle, hit by Karen Reed's vehicle, and she did not know, which is consistent with that 9-3 leaning towards guilt on the lesser included that numerous jurors have now discussed. That's consistent because counts 1 and 3 both require intent. So those statements are consistent with what the jury is telling us that they intended to do. The Commonwealth also filed a supplemental stating that a juror had called and left voicemails on Adam Lally's phone, and that jurors had emailed Adam Lally and said they reached verdicts. And Lally responded, "We can't promise confidentiality because things you say might need to be disclosed to defense or the court. And we can't talk to you about your thought process, your deliberations, but none of that says they can't inquire as to the result." So oral arguments on Friday, August 9th are going to be very interesting in this case. Here's what I think we will see. The court taking it under submission. I don't think the court's going to rule on this on Friday. And I think the court will do a written ruling down the road. The prosecution arguing that the court can't inquire on any of this and it's not double jeopardy. The defense arguing that the court must dismiss these counts because it's double jeopardy, and in the alternative, arguendo if you will, arguing that at a minimum, the court needs to at least poll the jury or allow the attorneys to get affidavits from all 12 jurors to confirm that they were in fact unanimous. I think that is the best outcome and the most possible for the defense. The court is not going to dismiss these counts. If the court denies all of this out front, then it will go up on appeal. And that's where we're at before the hearing on Friday with the Karen Read case. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.